You've been appointed the personal representative of a deceased probate estate, and now it's time to publish. Hi, I'm Darren Findling of the Probate Pro, and we're going to spend some time discussing how notice is provided to creditors. Now, creditors can occur in two different forms. Known creditors, these are creditors that you are aware of, or you should have been aware of by simply reviewing the mail. A known creditor may be a credit card statement, a medical bill. It could be the neighbor down the street. It is a creditor which you already have the information about the debt. And in a prior video, I have explained how to give notice to those known creditors. It's pretty simple. You fill out a form and you send them notice. In this video, we're going to discuss unknown creditors. These are creditors that you don't know of or wouldn't be aware of. It could be also the neighbor down the street, but more typically it's a medical provider, a credit bill, a credit card, things like that. So how does Michigan law provide for notice to unknown creditors? Well, it's through a publication process, publishing in the legal news. Now this process is really archaic. It belongs from a prior generation in which newspapers were the way people obtained information that were widely circulated among populations. In today's day, it doesn't really make sense because who reads these legal newspapers? No one. In fact, the only people or entities that read legal newspapers are the creditors that are searching those legal newspapers for this data. You may have seen in a legal newspaper notices, columns within that newspaper that identify the publication of somebody that has died. Similarly, within a mortgage foreclosure, you see these listings. But these legal newspapers really have not a wide range of circulation. It's not like the general public is reading a legal newspaper and saying, oh wow, somebody just died, I better file a proof of claim because they owed me money. That's just not the way it works. But our statutes have not caught up to modern times. And we still use this publication process in a legal written newspaper rather than using the internet and all sorts of other techniques that could be used to ensure that notice is better provided to unknown creditors. There are all sorts of ways that we could do so, and that unfortunately has not caught up. This process has not caught up to the times. We're going to examine the timeline upon publication as well as the relevant statutes that apply to giving notice by publication. Now, if you look at the general timeline of probate, publication occurs really at the onset of the appointment of the personal representative. This is governed by both a state statute, MCL 700.3801, and a court rule, MCR, Michigan Court Rule 5.208. It is these two, the statute and the court rule together, that dictate how a personal representative is to give notice. So here's what the statute generally says. When you're appointed personal representative, you are obligated to give notice to any of the unknown creditors by publishing in a legal newspaper in the county upon which the decedent resided or a county upon which the court is managing the deceased estate. Publication occurs for 4 weeks, and this is a requirement, a mandate of the personal representative or special personal representative to do so unless notice has been given before. Now, there are times that notice is actually done in advance of the personal representative being appointed. One obvious example is if you're the successor personal representative. But also publication can occur with a trust administration. So if it has already occurred, you're excused from publishing. In addition, there are other reasons that no notice is required. For example, if the person has been deceased for more than 3 years, and then you begin to probate the estate, the reason no notice is required is because there's a statute of limitations for creditors. Creditors have 3 years to bring forth their claims. They can do so by opening up the probate estate or by filing a lawsuit if no estate has been opened. So if 3 years have gone by, you don't need to publish. In addition, there's no notice in the event that the estate has no assets or assets that are so small, de minimis sized assets within the estate, because under Michigan's priority statute, before a creditor would ever get paid, certain administrative expenses and funeral expenses and exemptions and allowances are entitled to be paid. So if the estate is small, you may be excused from giving notice by publication. But for most estates, the estate is opened and you publish in the legal newspaper and then provide an affidavit in the probate court that you concluded or completed that requirement of publication. Let's examine the actual notice that is submitted to the legal news for the publication. The form itself is PC 574, Notice to Creditors. It is a notice that you complete, but then is turned over to the legal news, and it is this information that then makes its way into that column for publication. At the top, it identifies the name of the form, and at the bottom, the state court administrator approved form, as well as on the bottom right, really important information, the statutes and court rules that apply to that document. As with all of these forms, it is that information on the bottom right corner that I find particularly important, because it allows you to reference the statute and court rule that apply to completing that form correctly. Again, we strongly urge people to use a lawyer through estate administration, because doing so will ensure that you fulfill your obligation. The reason this is so important is if you fail to give notice correctly, if you fail to publish, fail to give notice to known creditors, fail to monitor the mail correctly, and then you distribute, you can be held personally liable for any creditor that comes forward that you failed to appropriately provide notice to. Within this form, top left corner is the county, and in the top right corner is the case number. Pretty intuitive, pretty easy to fill out. The next area is the name of the estate and the date of birth. The date of birth allows for somebody, a creditor, to distinguish between people with similar common names. The next section identifies the date of the person's death and the address of the personal representative. And a creditor can file their proof of claim by submitting it to the personal representative and or filing it with the probate court. But it sets forth the time bar, which is a 4-month period of time that after notice to known creditors are completed, there's a time bar to any of the creditors. Now, it's important to distinguish between the time bar that I mentioned earlier, which is a 3-year statute of limitations for presentation of creditor claims in the event that no estate has been commenced, and the 4-month creditor statute of limitations when publication is given to an unknown creditor. This is different than a known creditor statute. So sometimes people mistakenly confuse the fact that they published but then didn't give direct notice to a known creditor. It does not excuse you for giving notice to a known creditor if you have published for unknown creditors. You're required to perform both responsibilities under Michigan statute and Michigan court rule. The next section identifies if there's an attorney and the personal representative information, so that when notice is then published in the legal news, it identifies for the creditor where to submit the creditor claim. For each county, it's handled slightly different as to how that form is then managed with the legal news. Some county courts actually will turn it over to their legal newspaper that they're affiliated with, and most require you to turn it over to the legal news so that they can publish. The responsibility is on the personal representative to perform the duty. It's not up to the court, and often I find clients come to me after they've been administering an estate for a period of time and they just didn't even realize the responsibility of publishing. It's a critical role in this entire administrative process. I hope that this video has been helpful, and if I could give you one piece of advice, if you're administering an estate, please work with a competent, skilled probate lawyer. It's going to help you through this process and ensure that you're performing all of your legal responsibilities correctly. If you have any further questions of us, give us a call at 833-PROBATE or visit us at theprobatepro.com.